What is the best defense in a debt collection lawsuit? Hey everybody, my name is Hannah with Solo Suit, and in this video, I sit down with a consumer rights attorney named John Skiba, and we go over this question. Hopefully it'll point you in the right direction to defending yourself if you've been sued for debt, and give you some ideas on how to respond to debt collectors in general, but not just respond, how to resolve your debt once and for all. So stay tuned and check it out. What do you think are some of the best defenses that you can use in a debt collection case to either get it dismissed or to reach a settlement?
The first thing you have to do is file a written answer in most situations, particularly if you're not sure what to do, if you don't know if you have the ability to offer a settlement, or maybe you don't have the ability to right now, but maybe you will. Filing an answer will help you to avoid the default judgment. And if you don't file the answer, which is just your written response to this, if you don't file that, the court will just give them everything they're asking for. And if they have attorneys, they can add attorney's fees, they can add interest on top of it. So filing the answer is the first thing you need to do. But a couple of things with filing an answer. I always say the answer is super important. It's generally probably the simplest stage of the lawsuit because it can be fairly straightforward. I know with Solo Suit, you guys have tools and things that can help people put it together. It has to be done correctly. And that's why I like tools like Solo Suit that can help you put it together, because I see, and we can maybe go into mistakes, but I see when people draft it themselves, the biggest mistake they put is they put way too much information in their answer. And it can actually harm you to do that. At the beginning stages, all the court wants to know is, is there an actual dispute? You know, you should view the lawsuit as this is the junk debt buyer or the creditor, whoever it is, saying, hey, here's my allegations. And the court's basically saying, okay, Mr. Consumer, Mrs. Consumer, what do you say? You know, what's your response? Do you admit or deny what it is that they're alleging? And if you deny it, then the court's saying, okay, we have a dispute. That's what we're here to do. We're here to resolve the dispute. So filing an answer is the first thing that you need to do, whether you're going to focus on settlement, whether you're going to try to take the case to trial. The biggest defenses I see is that, particularly as it relates to junk debt buyers, and I kind of break these up into two categories. Original creditor lawsuits, often like American Express, they usually file their own stuff. Sometimes they'll sell it, but usually they file their own lawsuits. Or if you get sued by portfolio recovery associates. I often treat those defenses differently. Original creditor suits are a little harder. They're quite a bit harder, unless there's like an identity theft issue to prevail on. But junk debt buyers, you've got to kind of get the bigger picture of what they're doing. When they go pay 4 cents on the dollar for these accounts, they don't get a whole lot in return. Often they get a spreadsheet. They might get one or two monthly statements. They get a spreadsheet with some, name, address, account number, that kind of thing, which in a default context ends up being okay, that's enough because nobody's fighting them on it. But when you contest it, they often don't have a lot of the documentation or the witnesses that they need to be able to establish their case. And so by filing an answer, all of a sudden now you put their feet to the fire, but that they've got to prove their case. I think that's one big kind of thing that people don't understand, is that they're the plaintiff. The creditor has to prove all of the elements of their case. You don't have to disprove anything. LVNV sues you. You don't have to prove that you don't owe it. They have to prove not only that you had the original contract, but they've got to show that they received it and that they own it. And if they can't do that, the court shouldn't grant them a judgment. So there's many defenses related to the sufficiency of their documents, their witnesses. I've done over 400 trials against junk debt buyers. I've never once had an original creditor witness appear. But having the original creditor witness at a trial is super important, and they just don't have it. It's not in their contract to have these people fly in or even appear over the phone. So often pressing that issue as far as the sufficiency of their documentation, their witnesses, that can be a good defense. And then a lot of times we'll push cases into private arbitration. It's not really a defense, but it's an approach where they typically don't want to deal with the case in a private arbitration setting that's like outside of the court. I always say if you're going to ask the court to push it into private arbitration, it's something you need to be prepared to do. I do a number of those, and they will follow you in sometimes, so you need to be prepared to do it. And then you also need to ask yourself, what do you consider winning the case? Air quotes, winning. Because sometimes settling the debt is a great way just to get this thing done, and it's a win. It can be done very quickly. I know Solo Suit has some products and a platform that can help you with settling the case that could make this thing go away quickly. I do tell people, if you're representing yourself and you get sued by a debt buyer and you're like, okay, I'm going to take it to trial, that's fine, but be prepared. This thing's going to be part of your life for the next 6 to 12 months at minimum. And it can take over your life. And you're at night researching it and watching YouTube videos with us and that kind of thing, trying to figure out how to figure this out. Sometimes settlement can be the quickest way, and it often is the quickest way to get it resolved, is by coming up with some type of plan to go in and offer something less than what it is that they're asking just to get it resolved. So those are kind of the main things. I know I'm kind of going on here, but that's kind of the main approach I take to these cases.
Yeah, so let me just recap. The best defense that you can use in a debt collection case is just to file an answer, because oftentimes junk debt buyers won't have the necessary documentation to prove their claims. At Solo Suit, we're not attorneys, so we can't give legal advice. And I know that you can't give legal advice either unless you're officially representing someone. But typically, we've seen in our experience that it's best to deny as many claims as possible to force the junk debt buyer to prove their claims, right? And if they can't, then the case may be dismissed, or you might be able to have a better chance at settling. And you're right, yes, at Solo Suit, we do offer documentation. We offer people a template that they can use to respond to a debt lawsuit. It's called our debt answer. Not only does it give people a chance to respond to each claim that's against them, but it also gives them an opportunity to assert their affirmative defenses. Thanks everybody for watching. I hope you found some answers to your questions. And if you feel like you need more help, head over to solosuit.com. We have a blog with lots of resources that can get you more answers to more questions. On top of that, we have products that can help you respond to debt collection lawsuits and settle your debt outside of court. So if the thought of representing yourself in a debt collection lawsuit intimidates you, or if negotiating a settlement seems scary, go over to solosuit.com. We can help you respond to a debt collection lawsuit, settle your debt outside of court, and empower you to represent yourself in resolving your debts for good. Thanks so much for watching, and good luck with resolving your debts. Solo Suit is rooting for you.